Good morning, everyone. I welcome all of you to another episode of Learning the Law with Dushantha Kularathne. First and foremost, I should emphasize that the content of this program is for informational purposes only and it does not constitute legal advice. It shall not be construed as an offer to represent you. Having said that, I will straight away come to today's topic, that is adoption. In Sri Lanka, adoption is governed by the Adoption of Children Ordinance. What is this adoption? Basically, if a man and woman lives together, as a result of that union, the children will be born. So basically, these children will be brought up by these two individuals who are called biological or natural parents. But when a child is brought up by parents who are not biological parents, with the assistance and through the strength of a court order, that process can be identified as an adoption. Under Section 2 of the Adoption Ordinance, any person who is desirous of adopting a child can make an application to court. What is this court? That is the district court in which either the child is residing or one of the parents reside. When an adoption order is made, court has to consider several aspects to look after the best interest of the child. Because in Sri Lanka, the district court is the upper guardian of children. Under Section 2.2 of the Adoption Ordinance, it says, no adoption order should be made with regard to applications made by two or more persons. So does this mean that two or more persons can't make applications? No. Law always provides provisions for exceptions. We call it provisos. So the proviso here is two spouses who are legally married can make a joint application to adopt a child. Section 3 of the ordinance provides restrictions. The adopter or if it's a joint application, adopters should not be below 25 years of age. And there is an age gap also between the adopters or adopter and the child. That's 21 years age gap should be there between them. For instance, if the child is 5 years old, the adopter at least must be 26 years old to be qualified to make an application. But there are exceptions to this rule as well. If the child is a direct descendant of the adopter or brother or sister of the adopter, full or half blood, or the child of the wife or husband of the adopter by another father or mother, as the case may be, court may, if it thinks fit, allow such an application irrespective of that age differences. But there is another restriction. If the sole applicant is a male, court will not ordinarily make an adoption order in respect of a female child. However, if the court finds that there are special circumstances to permit such an adoption, court might permit that as well. An adoption order shall not be made without the consent of every person who is a parent or a guardian of the child, or who has the custody of the child, or who is liable to contribute for the support of the child under Section 3 of the Adoption Ordinance. However, such consent can be dispensed with by the court if that particular person has abandoned the child or deserted the child, or if he cannot be found, or if he has been adjudged to be mentally unsound by a competent court. Or when it comes to a person who is liable to contribute for the support of the child has neglected such support. Who is the person who is liable to contribute to the support of the child. According to the Act, a man who marries a woman who is having a child by another man is supposed to be a person who is liable to contribute to the support of the child. When it comes to an application by spouses, the consent of both the spouses is important, otherwise there will be family problems. And when it comes to adoption ordinance, it says adoption order shall not be made in respect of a person who is not resident or domiciled in Sri Lanka. Does this mean foreigners can't adopt children in Sri Lanka? No, it's not the case. Here also there's a proviso or exception. Adoption order may be made by a court of law in Sri Lanka on a joint application of two spouses who are not domiciled and resident in Sri Lanka, where after calling for and considering a report from the Commissioner of Probation and Child Care Services on the social, psychological aspects of the adoption to be authorized. Court shall be satisfied there are special circumstances to make such an application, to authorize such an application. So here the Commissioner of Probation and Child Care Services should annex a home study report in respect of the applicants from an institution recognized by the country of the applicants and authenticated by the accredited representative for the Republic of Sri Lanka in that country. So what is this home report? Home report, it's a report on the mental health of the applicants, their social, religious and financial background, and in their, especially their suitability to adopt a child. Under section 4, court should be satisfied about several grounds before making an adoption order. One is the consent is given by every person who is supposed to give consent to such an adoption, basically mother, father or guardian who has the child's custody, so on and so forth, unless that consent is dispensed with, as we discussed earlier. Basically, this adoption order should be for the best interest and welfare of the child. No consideration or payment or reward can be passed in connection with the adoption. Considering the best interest of the child, court can make certain terms and conditions, maybe requiring the adopter to enter into a bond to provide for the child, so on and so forth. Basically, when an adoption order is made, all rights, duties, obligations of the parents, biological parents or natural parents shall be extinguished and vest in the foster parents or adopted parents. That is important. Court similarly shall confer on the child the surname of the adopted parents or the family. In Sri Lanka, basically we give father's name. Upon an adoption order being made, the adopted child for all purposes whatsoever be deemed in law to be the child born in lawful wedlock of the adopter. Basically, after an adoption order is made, adopted child is considered to be a lawful child of the adopted parents, and he has all the rights similar to rights of a child who was born to them in their lawful marriage. Section 6.5 is also important. It says if the adopted child dies intestate, that means without a last will, adopted parents cannot claim that property by reason of adoption. So under section 10 there is an adoption register that's maintained, but it is not a public document. Everyone can't inspect or search that without a court order. Similarly, under section 14, receiving money or reward by adopted parent is also an offense. So that's all for the adoption. I don't go into detail about other certain areas like getting surnames of the adopted parents, so on and so forth. So that's all for today. Let's meet up with another episode of Learning the Law with Dushantha Kularathne. Thank you very much.